received his undergraduate degree from the University of Southern California and his Juris Doctorate degree from Duke Law School. Next, we have Mr. Kevin Ford. He is the Executive Director of Uplift Action Fund, Inc., which is a 501c4 organization that focuses on advocacy, on responding to elected officials who have prevented restorative justice to families and communities harmed by the war on drugs. UAF organizes supporters to affect federal and state policy that legalizes adult use of cannabis. Next, we have Ms. Amber Hendricks. She is the she was appointed Deputy Director for Prince George's County Office of Management and Budget in 2015. She has worked in the office for 18 years in various positions. She holds a Bachelor of Arts degree in Political Science from Spelman College, and she holds a Master's in Urban Affairs and Public Policy from the University of Delaware. Our next panelist is Ms. Beth Huffnagel. She served as lead for the Maryland State League of Women Voters Redistricting Advocacy Team and is former president of the Howard County chapter of the League of Women Voters. She was the 2020-21 member of the Howard County Racial Equity Task Force and is a retired professor of astronomy at Anne Arundel Community College. Next, we have Ms. Tracy Thompson, a resident of Bowie, Maryland, who joined both the local and Maryland state chapters of League of Women Voters and is a member of its Maryland Redistricting Advocacy Team. And last but not least, we have our moderator, our chapter's own council member, Erica Fareed. Ms. Fareed is a council member for the city of Glenarden and has been so since 2021. She is now chair of the Charter Review Committee and has over 20 years of process optimization and agile business transformational organization leaders in various companies. And so without further ado, we want to thank you again to our panelists for joining us. And I'd like to turn it over to our illustrious moderator, council member of City of Glenarden, Erica Fareed. Thank you.
Thank you so much for that. We're excited to get started this evening. We have a lofty agenda, so let's go ahead and get in contact. And started with question 1. So just want to make sure got it. And could you please make sure that Ms. Amin is spotlighted? Because this question is for her. Hi, thank you so much, Clerk Amin, for joining, and it's good to see you again. I don't know if you remember, but you swore me in last year.
It's good to see you. Thank you for having me.
Yes, thank you. So question 1 relates to changes in the name of Maryland's appellate court from the Court of Appeals to the Supreme Court of Maryland and from the Court of Special Appeals to the Appellate Court of Maryland. Could you give us a little bit of context on why this change is being made?
Basically, this is to limit confusion. So there are 3 courts in Maryland. You have the district court, well, 4 courts: the district court, the circuit court, which is your trial court, the Court of Special Appeals, which is your middle court, your middle appellate court, and then your highest court, which is the Court of Appeals. 48 other states have the naming of their court system like the one that's being proposed. So we are, or the judiciary is seeking to limit that confusion, and it's easier for practitioners, it's easier for research purposes to say that the Supreme Court, the highest court in the state of Maryland, is the Supreme Court. And then instead of the Court of Special Appeals to be the Court of Appeals, it really does limit that confusion.
Great, thank you. That's great context. And I can see how that would be important from state to state in making sure that other people understand Maryland law and the decisions.
Mhm.
Could you talk a little bit about what we can expect to see change as a result other than the names? So I think the names of the judges will be changed to justices and.
Yes, that would be just in line to kind of like the federal court system where you have the Supreme Court, they're called justices. And then in all the lower courts, there still will be referred to as judges. It's really more so in name, and then changing the different captions when you're filing something into court and everything going forward. Under the law, they'll be required to use up all their letterhead with the old name, and it doesn't change. It doesn't change. It doesn't change the context or the content of what they're doing. It's just literally making it easier and simpler for the people who are interacting with the court, researching the court and case law and things like that. We're not going back and, changing all the hundreds of years of case law like that, or, that's just impractical.
Okay, great. So is it fair to say that it's just sort of title changes and that there are no shifts in duties or salaries, or is it?
Yeah, yes, that is correct. If there was a change in salary, it would be a whole nother discussion. I'll tell you that. But so that's a whole nother separate issue. But yeah, it's literally to simplify the system. And I want to say this might be like the third time or the fourth time they've tried to do this. So for it to be a constitutional amendment is a pretty a big feat. And just another little bit of history is the Court of Special Appeals. It was actually established to kind of take some of the burden off of the Court of Appeals. So that's why you have the name Court of Special Appeals in there.
Okay, great. So that seems like a pretty good response. And we want to see if we have any questions from the audience on this item.
Councilmember Fareed, I do not see any questions in the chat on this question, which is good. We have 5 minutes left for this question, but we can move on to question number 2. We will be back with our clerk of the circuit court as she has another question that she will be responding to. Question 2, please.
Question 2, it says something that sounds totally obvious. Someone who's a delegate or a senator should live in their district. Now, there's a little argument about what live meant, and it used to be a little wishy-washy, or it still is a little wishy-washy. Maybe they stay in a rental place now and then, or they have a vacation home in the district that they wish to represent. And that is legal as of now. What this constitutional amendment will do is tighten it down to this has to be your primary residence. You really need to live in the district of which are either the delegate or the senator. And it sounds completely obvious. Everybody should be doing that. However, there's a little trick, which is, now let me go back to why they picked me to talk about this, because I do redistricting. So every 10 years, and this year was particularly slow in establishing what the district is. And there are some people who maybe with redistricting will pull the rug out from under someone who's represented an area in a long time and move the lines so they're not in the district they've been in for a long time. So this, and that means you got to move, and you have to move either by the time the district is decided, and it was really late this time, or 6 months before the election, the general election. So although it sounds completely innocuous, if you have gerrymandering, which by I mean is where lines are drawn not because they're fair, but for political purposes, this actually can be quite difficult for someone who really wants to serve their district to comply with. It can be difficult. And the notice you get for where those lines are going to be can be very late. And if you actually have to really, really move, across the street, even wherever it is, that could make this difficult.
thank you for touching on that piece around what makes this difficult. Can we explain that a little bit more? Is there any, how does it, are those candidates impacted if the change happened and they're already living in a certain place? Would they really to move across the street, or?
Yes, that is the requirement here. If you are wanting to represent your district and the district moves, then you need to move, and not just, have a connection to where the new place is. But again, that only happens every 10 years. So this is not something that happens, with every election. It's only with the census cycle, which is every 10 years, and the redistricting, which only happens every 10 years. The next time is going to be the census in 2030.
Okay.
I see someone has asked, how can the realigning of the districts be stopped? Well, you really don't want to. What's happened is people keep having children. They keep moving. More people, they love Maryland, they're coming into the state. So our population is increasing. So you want to make sure that every district has the same amount of voters in it. Because if you have a small amount of voters, then they have a whole lot of influence on their delegate or their senator. If you have a large amount of population, then they have less influence on their representative.
Okay, are there any other questions?
No, I'm sorry. There are questions coming in. So the first question from the audience is, can you explain resided versus maintained?
The way they want to change it to is you actually have to have your primary residence is where you reside and maintain a residence, not just occasionally I have lived there, which is the way it is now, which is a little squishy. You can be a little not exactly a full-time resident. You don't have to be. Under this constitutional change, it makes it stricter. You actually do have to really live there.
The next question is, if we answer the question no, meaning we answer against the constitutional amendment, does that mean that the senator can live in any area, or delegate can live in any area?
Yes, I get it. They can have their primary abode where they spend most of their time, can therefore be anywhere. Yes. In the state. No, not just anywhere, but in the state of Maryland. Yes.
Okay. Just a reminder to our listening audience, please mute your microphones. We have quite a few, several hundred people on, and so we're not able to get through everyone, but please mute. The next question is, this might sound strange, but can't there be a time deadline for redistricting to be completed by a certain date to allow for candidates to move should they choose to run?
Again, an absolutely reasonable suggestion, and you would think that there would be enough time to have it in. However, this particular year, which I'm crossing my fingers in 2020, was unusual in that the Census Bureau was caught up in a lot of proposed changes, and COVID hit. It was a very difficult year to meet the deadlines and get the right numbers out. And the Census Bureau is required to get the numbers to be as close as they can. And it took months more than they had expected to do that for those two reasons. COVID made it difficult to finish. And the second reason was there were a number of legal issues that came up that prevented them from finalizing the counts until months after. So I'm hoping in 2030 that everything will go according to plan. I'm hoping, and the apple cart isn't upset.
Great. The next question is how many persons that are elected are actually affected? Does that make sense to you?
Absolutely. The people
Okay.
drawing the maps are the ones who may be tempted, to draw them in a way that makes the incumbent of, say, the other party have to move, if I might put it that way.
Okay. And make sure someone said that I had missed two other questions above that. The next one is who is responsible for compliance and enforcement of this constitutional amendment passed?
That is an excellent question. I really don't know exactly who is. Traditionally, what happens is there is someone who files a complaint. And I honestly, I do not know to whom. My guess, and I'm guessing, would be the Attorney General or the State Board of Elections, that some third party would have to say, hey, that person doesn't actually live there. And then the State Board of Election would be the persons who do compliance. But I do not know that one, I'm sorry.
Okay. Once again, we've reached the 5-minute mark. We're doing really good. Just make sure I got all the questions. I got a direct question to me about whether or not the questions that we're seeing on the screen, is that how it's actually worded on your ballot? Yes, we took these straight from our specimen ballots that were received from the Board of Elections. Let me just make sure that I didn't miss any others. Councilmember Fareed, I think we are finished with question 2 from both us and the audience. We can proceed to question 3. Thank you.
Okay.
Thank you.
Thank you, Beth. And let's take it back to the clerk for question 3.
Okay. So question 3 is basically saying that in order for civil actions to have a jury trial, with the amount in controversy, basically the amount that you're suing for would increase from $15,000 to $25,000. So basically that would keep that $25,000 and under would keep the threshold for cases to be had in district court or held in district court before you can file for a jury trial in circuit court. And just a little understanding of the court system, the district court is our lowest court, and that is it's our lesser offenses, our small claims, to kind of say our landlord tenant stuff. And it's basically the judges. There are no jury trials in district court. You can file in circuit court, but there are certain requirements that you have to meet. And this would change the constitutional amendment to where it would be $25,000, excluding attorney's fees. And so one of the big things about this is, one, it will take the burden off of the circuit court and give it more to the district court to hear more of the cases. And when I'm talking about civil cases, we're talking about things like car accidents, a breach of contract, anything where there's some type of damages. And there's a lot of stuff that takes place when you go to a jury trial. It's longer, it's more costly. The period of, like what you call discovery, where you're learning about the case and you're putting on your defense and things like that, that's longer. District court, it moves things quickly through the system. It's just a way to kind of move things faster. There's pros and cons to the $15,000 versus the $25,000.
Thank you. So when you say it's more costly for us as citizens, or is it more costly for the parties in the lawsuit?
Well, generally speaking, it could be costly for both, because when you have jurors, you have to bring those jurors in. I mean, granted that, I think the fee is actually, the compensation is going from $15 to $30 or $45. I can't remember. They just passed that bill last session. But you have to bring those folks in. You have to, pay for the time, you have to pay for, I mean, we're paying for the judges and everything like that, but it's a high volume. So the taxpayers do have a cost associated with that, as well as the actual parties to the case. Because when you have to pay a lawyer, I mean, that's usually, you know, it's based off of either billable hours or contingencies. Trying a case with a jury is very expensive. You have experts and you have, you know, evidence, you have to prepare for it. So it can just be really costly. And like I said, the time period between district court and circuit court in order to try a case is shorter. So it moves cases along.
I think we have somebody that's not on mute. Please mute your phones, please. We're sorry.
Yeah, no.
Please proceed.
Yes, it happens. But so that's the general basis of it. I do know that like the Maryland State Bar Association is in favor of this bill, but the defense bar is not necessarily in favor, because, you know, they're saying that it can limit defendants to their right of a jury trial, to have a jury by their peers, and not giving them the benefit of being in circuit court with a jury trial.
Mm-hmm. And so that's a good point. And that leads to another question in terms of people's rights to trial by jury. I thought that was only for criminal cases, but this is civil. So is that right also afforded to civil defendants? And if so, then how can we even vote on it? Like,
that's why you have the case in controversy, the amount in controversy. So if it's $25,000, you do have that right to pay a jury trial, and it's up to the plaintiff on where they file. So the plaintiff can decide to say, hey, I'm going to file in circuit court, or I'm going to file in district court, and then the defendant can say, well, hey, I want to have a jury trial, so they can ask for the case to be heard they can ask the case to be heard in circuit court.
Okay, great, thank you. And the amount, $25,000, is that just some arbitrary amount, or is there some math behind that if we move to 25,000, it'll reduce the volume by X amount?
Well, I can't tell you about those kind of figures, but what I can say is that over time the amount has increased. The amount in controversy. It first started off with $5,000, and then over the years, it's gone from $5,000 to $10,000, $10,000 to $15,000, and now we're at $25,000. And you have to, if you look at, you know, inflation and how much things have cost, you know, all that stuff adds up. So this is probably kind of closer in line to how expensive it is to, you know, kind of live in the United States and live in Maryland.
Okay, great, thank you. So that's it for the questions I have. I do see some questions here in the chat.
Yes, there are some questions in the chat, and just as a reminder to our panelists, our audience would like us to read the questions ahead of time before we jump into Q&A and explanation. So just a reminder, I think we sent that in the initial instructions, but let's go back. So one of the questions needs confirmation, asking whether $25,000 means that it goes to a higher court, and under $25,000 to which court?
Okay, so that would be in district court. So basically that's your threshold. District court and circuit court have district court has concurrent jurisdiction with circuit court. Basically, there's a certain amount that either party can file, right? And so right now, anywhere a person can file, if the claim is between $5,000 and $30,000, they can decide whether to file in district court or circuit court. Okay. And if the plaintiff says, hey, I'm going to sue for $25,000, I want to go straight to a jury trial, then it takes that jurisdiction away from district court, and it basically, you file in circuit court, and then that's where you start your case. If they say, hey, I want to file in district court, and the defendant says, well, I want a jury trial, they have to have that $25,000 threshold to say, let's go ahead and move it to circuit court. It can get a little complicated.
Okay. We have a few more questions for you on this. One asks, what is the benefit for this constitutional amendment? How does it adversely affect cases under $15,000?
Well, under $15,000, like I said, you stay in, you're in district court, and the cost to litigate a case is very expensive, and you want to do it expeditiously, because the longer you're waiting in court, the longer the case sits around, and you basically don't have a resolution. Okay, and so district court, they move things quick just because of the rules, the Maryland rules of procedure in district court cases. It just moves it faster along. It's more efficient, judicial economy. And if you can just imagine all the fender benders that we have, those people are going to court. And if you get injured, I mean, do you want to sit around and wait for a year and a half, 2 years for your case to be heard in circuit court for the jury? Or do you want that resolution where you have one judge and they can it moves your case quickly?
Okay. The next question is, are the district court judges appointed or elected?
They are appointed. District court judges are appointed, and the circuit court judges are appointed, then elected.
Okay. The next question is it the same dollar amount threshold as small claim cases?
The small claim cases, that's a little different sect within district court. And so I want to say, I was talking to my father about this earlier. I believe the small claims might be $5,000. And if you don't win in small claims, or you don't like the resolution, you can get a new case in circuit court. So you have like a right to an automatic appeal, basically, in circuit court, versus going to the Court of Special Appeals.
Okay. So someone wants to know whether or not you can actually still get, if this amendment passes, can you still get a jury trial in district court?
If this amendment passes, you would have to meet that 25,000 threshold in order to get a jury trial. And the jury trial would, when you play a jury trial, it takes it from the district court to the circuit court.
Okay. Next one, district court. If whoever signed in as Blessed Lady, and you entered a question at 7:10 p.m., can you restate that question? I'm not quite understanding it. Another question is the purpose of this question to save the court's money, and is there a benefit to the plaintiff?
Well, it depends on who you talk to, the benefit of the plaintiff or the benefit of the defendant. That's why there's the pros and the cons. This one is actually a little bit tricky because it's like the defense bar. So if you're a defense attorney, you kind of, you want to be able to have a jury trial with the amount in controversy being $15,000 or more. If you're a plaintiff, or let's say you're the one who gets hit, and you're like, hey, I want to move my case because I want to get my money. It's quicker. It would be quicker basically in district court. And district court is used to having those high volumes. So, I honestly, I go back and forth on this question on where I would land. And I think the voters would have to basically say, what would I want if I was in that situation? Right.
And my my tech committee is telling me that that was the last question, but just for clarification, to Madam Clerk, are the district court decisions decided by judges or juries?
The district court, yeah, the district court it's by judges. The circuit court, the only court that has a jury is circuit court.
Okay. Okay. Well, thank you for that. I'm going to ask you, as well as our previous panelists, to continue to stay. We are going to, if time permits, if there are people who may have come on late and had a particular question about one of the questions that we covered and they didn't get to get their question answered, we will try to make sure that we do that at the end. But now we can, Council Member Fareed, we can move to question 4.
Okay, thank you. Thank you for this question. I think this is probably one of the most controversial questions on the ballot this season, this election. And I'm expecting it will have a spirited conversation, pun intended. So let's go ahead and get started with this. The question is, do you favor the legislation of the use of cannabis, aka marijuana, by an individual who is at least 21 years of age on or after July 1st, 2023 in the state of Maryland? We have our distinguished guest, Mr. Ford, with us to give us his perspective on this. Mr. Ford?
Absolutely, thank you.
Yeah, give us some
Thank you
context
for
where this question is coming from.
absolutely, and thank you for having me. I would be remiss if I didn't bring greetings from the Gamma Pi chapter of Omega Psi Phi Fraternity Incorporated here in Prince George's County under the leadership of our boss list, Richard Allison. And question 4 is really, I mean, just that, a question. Should we allow the use of cannabis by adults 21 and over starting in July 1st, 2023? But one thing I think that people don't understand is the fact that behind this question, there is accompanying legislation, which is House Bill 837, which lays out some of the judicial points behind what legalization actually means, from the actual I guess, expansion of decriminalization, which happens as of January 1st, 2023, and then the actual legalization of limited possession as of July 1st, 2023. But this bill also lies out a couple other things, as well as establishing a cannabis business assistance fund. Also lays out different criminalization aspects as far as dispensing, possession with intent to distribute, as well as some limited expungement. It also creates a Cannabis Public Health Advisory Council and allows for the study of home cultivation for medical cannabis only. So there are a few different things that really fall in tandem with us voting for question 4 that I think the voters don't necessarily understand. So I definitely look forward to answering your question.
Great, thank you. Can you speak to what some of the benefits of legalizing marijuana is for recreational use?
Absolutely. So I think that first and foremost, it's in what has been passed last session in that bill that I just mentioned is really criminal justice reform. According to the ACLU, Black people in Maryland are still 2.1 times more likely to be arrested for cannabis possession than white people who actually consume at a very similar rate. But cannabis legalization will keep more Marylanders out of the criminal justice system by allowing for that use and possession of cannabis. The other thing that I think that it will allow for is additional economic opportunity. A major buzzword in the cannabis industry, and definitely here within Maryland General Assembly, is social equity, and making sure that folks who have been most harmed by the war on drugs are able to have a seat at the table to even first dibs on opportunities within the legalized and regulated industry, such as growers, processors, dispensaries, delivery opportunities, and then ancillary businesses such as transportation, security, and other things like that, as well as even testing. Aside from that, I think safe and affordable access is on the ballot as well. When you look at the medical industry, all of these products are well regulated, they're tested, we know what's in them. They test for heavy metals, for molds, for pesticides, and then also for the various compounds that are within cannabis as well. So it's important for, as we move into a legalized market, for consumers to actually understand and know what they're consuming, versus just using legacy market cannabis, as I like to call it, which is not traditionally or really at all tested. The last thing is that from a political perspective, I think that this is going to have some aspect on our commercial tax base here in Maryland. And if we're able to, legislate this right on the county level as well, I think that Prince George's County can be a leader in making sure that we have the growing and processing businesses that allow us to reap the benefits of the commercial tax that comes along with having these businesses in our backyard.
Thank you. That was an excellent response. It was quite detailed, and I do see some are asking for a list of those benefits. So maybe we can summarize that in the chat for everyone. But I wanted to zero in on your point around the criminal justice reform. What then for those who have been prosecuted prior to July 1st, 2023? What happens to them should this pass?
So what this bill does, it allows for limited expungement, and it's really contingent on voter approval. So we do have to actually vote yes on this referendum in order to reap the benefits of some expungement. So what we're looking at is automatic expungement for all cases where possession of cannabis was the only charge in the case, and the charge was issued before July 1st, 2023. It allows for individuals incarcerated for cannabis possession to petition for release and resentencing and provides that relief shall be granted unless they are serving a concurrent or consecutive sentence for another crime. It also provides that a petition for expungement for possession with intent to distribute cannot be filed until 4 years after the sentence, including parole and probation, have been completed. So, this is definitely a start. I know that cannabis advocates across the country are really looking for Maryland to be a leader, not only in social equity, but social justice reform, and making sure that we can right the wrongs that the war on drugs has had on our communities.
Thank you for that. So the age is 21. What would happen to those who are under 21 who were found to be in possession?
So under 21, there's a different set of laws for them. Essentially, what I would assume, and this hasn't necessarily been put into law yet or even put into regulation, is that there will be some type of remediation or type of program through the court that allows them to get some type of education about the plant, about the industry, about what cannabis legalization actually is and how that can actually affect them if they're using it. But it's still illegal and will be illegal for anyone under 21 to possess cannabis once this law goes into effect.
Thank you. As you know, I'm sure, in Prince George's County right now, we have a curfew for those under a certain age. What do you think the legalization of marijuana, because they will have access to it at some point or some way, whether it's legal or illegal, how do you think that will impact, our youth? And do you think that it could potentially set them on the wrong path by sort of validating the use of it through the legalization?
I think first and foremost, when you're talking about kids, and particularly those who are under the age of 21, well, number one, those who are using it are already using it, and I think that we need to be realistic about that and really provide that demographic with the proper education needed about not only cannabis as a commodity, but also cannabis as an industry. And I think that, there's also a certain allure to something being illegal. And I think that once you take that illegality away from this plant, that you'll start to see somewhat of a change in perspective. But also, obviously, pop culture, hip hop culture has a major influence and impact on our youth. And you could turn on any rap song on any radio station right now, and they're not even, bleeping out the I guess the insinuations of cannabis within the music. So this is something that our kids are hearing every single day. But I think once they start to see what all comes along with cannabis from the industry perspective, from the social justice perspective, from all of these things, and really just rewriting what the narrative is around cannabis in our communities, I think that we'll start to see a different type of impact in our youth and how the plant is actually interacting with them and how they interact with the plant as well.
Okay, thank you. We're coming up on time on this question, and I know there are lots of questions in the chat about this, so I will pause my questions. And
Yes, there are quite a few questions. So let's start with some direct ones. So one asks, if legalization is allowed, will this allow people to smoke cannabis in non-smoking areas?
No. And one thing that I think that is spelled out within the law currently, even under medical cannabis, is that smoking is a consumption method of its own. And smoking, again, is still not going to be allowed in any place where smoking in general, even if you're smoking tobacco, whether cigars or cigarettes, you won't be able to smoke there. Now, if there is some type of private facility where someone allows the consumption and particularly the smoking of cannabis within that facility, they will be able to have the go ahead to do so.
Okay. The next question is will the use of cannabis be taxed? They put a particular number at 6% or at some percent, or is that some legislation that has to be decided in the next legislative session?
Absolutely. So cannabis will be taxed for adult use. So once you see recreational cannabis come online in Maryland, there will be a certain level of tax that will include a state tax and likely a local tax as well. That information has not been codified into law yet. So that's something that will be discussed next session between January and April. So looking forward to doing the work around that.
Next is, do any of the accompanying bills that you mentioned also deal with driving while under the influence of cannabis, or any limits or any other limits?
So in terms of driving under the influence of cannabis, it doesn't specifically state that in the current bill that we will be voting for under the referendum. However, I do expect, and I know that they're doing some research on how to even be able to tell at a traffic stop whether someone is under the influence of cannabis. And just for a short definition, cannabis actually stays within your system for 30 days, and it essentially stays at the same level. So it's almost impossible to tell whether you just smoked, within the last 2 hours or whether you smoked 20 days ago. So I know that they're trying to figure that out, but as of right now, there isn't anything in the bill that speaks to that.
Okay. I'm going to skip this next one because it asks why, with all of the issues and concerns, why is this just a yes or no question on the ballot? But for the ease of printing a ballot and doing the ballot, it has to be done that way. But we can come back to that. someone indicated that they also were concerned about the large amount of tobacco. We've seen tobacco and infiltration of tobacco in vape shops and stores, and people driving after smoking and secondhand smoke. I think you kind of addressed that, but if you have any more comments, particularly about the influx of um, of tobacco stores and vape stores, and particularly in our county, Prince George's.
Absolutely. So I know that one thing that's a legislative concern and seems to be a concern of the community as well is that folks don't want dispensaries on every corner like McDonald's, you know. And I think that we have an opportunity because this is such a new industry to kind of shape it ourselves. And I personally agree with the fact that we shouldn't have dispensaries on every corner. However, I do think that people should have safe and affordable access to these products. And I think one of the better solutions to this is by having a non-storefront retail license where somebody might have some type of a storage facility where they can then do deliveries from that storage facility to the actual consumer. So that wouldn't put it on Front Street, you know, wouldn't be all in front of our faces and just, you know, right there in front of us, which I think is what most people are worried about. And as far as secondhand smoke, I think that, you know, over the course of the last 10 years, the legislators have done a great job in even cutting down the level of tobacco smoke that we've had in our personal spaces in public. And I don't see this being any different. I do know that, you know, the smell of cannabis can be pungent at times, and folks definitely have an issue with the smell of cannabis. But at the same time, I think once the laws actually rolled out and is legalized and folks understand what the rules and regulations are, that we'll be in a good place. And I don't think that it'll be so bad that it's overwhelming. Whereas like in New York, you're actually able to consume in public, or DC, it's really more so a slap on the wrist. But I don't think that they're going to go that route here in Maryland.
Okay, so this is going to be the last question, and then I'm going to ask you to put some resources in the chat. People want to hear a little bit more of the resources, but it's a long question, so bear with me. It says, beyond decriminalization, where do you stand on supporting licensing the business of those most harmed to be able to benefit from the anticipated new legislation? We all know that African-American sellers and growers have been most harmed by the criminal justice system. How will they be made whole?
So, and this is one thing that our organization, Uplift Action Fund, is continuing to fight for, is to ensure that those who have been most harmed by the war on drugs have the opportunity to participate in a legal regulated market. And, you know, I can speak for majority of the legislative Black caucus in saying that they want to see or want to ensure that we have adequate and fair minority participation within the industry. And what that looks like for me is equal opportunity, meaning really anybody has the opportunity to get a license and the opportunity to fail, essentially. But also, I think what legislators need to make sure of is that we have equitable resources so that folks who look like you and I don't only have the opportunity to enter the industry, but also have the ability to sustain. So I think that this whole fight is absolutely ongoing. I can guarantee you that, you know, folks are not staying silent on social equity and making sure that folks within our communities who, again, have been most harmed by the war on drugs have that equal opportunity to get in the game, just like the number of you know, multi-state operators and other you know, high net worth individuals have been able to benefit from this industry thus far.
Great. So, Mr. Ford, can you just stay on again, as I've asked the other panelists to do, in case there are other questions? There's a lot of debate going on in the chat, but I'm going to give you some homework right now. If you could provide two things, maybe if you could place in the chat your website and some information where voters can go to get more information and really understand the issues. Someone asked us if a summary of all the issues can be shared for question 4. So if you could not only put your website, but maybe some of those opening remarks that you gave, if you can just put that in the chat so that voters can make an informed decision, we'd appreciate that.
Absolutely, will do.
Thank you. And feel free to also put your contact information in case voters may have some specific questions for you that hopefully, if we didn't get to answer it today. And just once again, we are going to go ahead and move on to question 5, but as time allows, we will have a general open Q&A at the end.
Absolutely.
And if you want to scroll through some of the other questions and maybe respond to those, that'll be fine. You can disregard about there's an ongoing debate, so you can skip those as people are making more comments about where they stand on the issue.
Absolutely, I appreciate you.
Thank you so much, Mr. Ford. Council Member Fareed, I think we are ready for question 5.
Yes, and we'll have Madam Clerk to address this topic for us. This question relates to the repealed county elections of Howard County Orphans Court judges and requires the Howard County Circuit Court judges to sit as the Orphans Court for Howard County. The current law provides for the voters of Howard County to elect 3 Orphans Court judges. Under the amended law, a party could no longer appeal a final judgment of the Howard County Orphans Court to the Howard County Circuit Court and would instead take an appeal directly to the Court of Special Appeal. So this is quite a wordy question, a little tongue twister. But I'll ask you, Madam Clerk, just for those of us on the call, since we are representing Prince George's County, why is this a question that we should be concerned with?
Okay, so we are getting a serious history on the court system in the state of Maryland. So the orphans court is basically where people go when they are contesting, I guess, estate cases, basically. And this is important because as it stands in all of the 24 jurisdictions, except for Harford County and Montgomery County, the orphans court judges are elected. Okay, so you're still required to have this amendment in our laws. It doesn't impact us directly if you don't have an estate, or if you're not probating a case in Prince George's County, but you very well have a issue in Howard County. Now, like I said, Montgomery County has been through this, and Harford County has been through this. And we do have 3 judges that we elect here, but this wouldn't affect Prince George's County. This is because the orphans court judge is a part-time position. They get a salary, which is paid for by the county, of $55,000 a year. Now, you can imagine that these are folks who have practices on the outside. And so, they have to make their money. They have cases that they actually have to litigate themselves. So it kind of stalls estate cases, basically, probate cases, because of the calendaring. And the sponsors of this bill wanted to take that, and in terms of judicial economy and efficiency, and place that onus on the circuit court judges. That would mean probably having to hire another, or appointing another circuit court judge in Howard County to hear those cases. And like this question says, if someone isn't happy with how an orphans court judge rules in their matter, then they have an automatic right to appeal in circuit court, which is actually less expensive. than to go to the Court of Special Appeals. So it may not have a direct impact, let's say all that to say, it may not have a direct impact on us in Prince George's County, but I'm assuming some of the opponents to this referendum could see this matriculating down to other counties. I don't know of any talk of that happening in Prince George's County, just to clarify.
Okay, that's good. I think that's a lot to unpack there. And so I think I'm going to try and get a little piece of what you just spoke about around the impact of the other counties. And I think you answered this in your response, but just to get it a little more pointed. Which process is more consistent with the majority of counties in the state of Maryland?
That would be having the orphans court judges, where if you basically go to the register of wills, if there's a will, and your case is probated, and that the orphans court is the one that does that process basically. So this would, Howard County, if this referendum passes, then they would be in the minority.
Okay, got it. Thank you. Are there any questions in the chat for this one?
I do not see any questions in the chat on this issue. And so I just want to make sure, because I was monitoring the chat, I want to make sure that I heard it correctly myself to the clerk. So why is this, why does the entire state have to vote on something that is only germane to Howard County?
Because you're basically you're amending a law, and generally speaking, they are basically saying they want to annex from the current law of the state of Maryland, saying that each jurisdiction has an orphans court judge. So they're saying we don't want to be a part of that system. Now everyone has to decide whether or not they're going to be no longer in that sandbox.
Okay, so presumably the folks in Howard County, they're encouraging them to vote for the constitutional amendment. For the rest of it, I guess it doesn't really, does it really matter?
In terms of, so if you happen to have an orphans court case or, a probate case in Howard County because you have a loved one or somebody like that who actually resides in Howard County, and you have to be the one to, take that matter through probate, you might well be affected. You just never know. But it's something like, do you want this? Is this going to be a precedent for the remainder of the rest of the state? I believe there is one of the orphans court judges in Howard County is opposed to this bill. So there is some, or not the bill, but to this referendum, there is some opposition in Howard County to this. So it's a hot button topic there.
Okay, I understand. Since as I live in Prince George's County, how will I appeal a case? The question asks, did you say that Hartford County and Montgomery County have already made this change?
Yes, Hartford County and Montgomery County are the two counties that no longer have an orphans court judge. The circuit court judge hears the matter.
Okay. The next question, and this is going to be the last question because I think I got the 5-minute warning. Is this change, do you think this change is necessary in Prince George's County?
So in my perspective, no, I don't think Prince George's County would be impacted by this referendum. And I don't think that as of now, now we need something like this to where the circuit court should handle probate cases. So that's just my personal opinion.
Okay. And then there's a last question, but I don't think it's necessarily germane to this particular question. It may actually go back to the first question. So I'm going to ask if you could take this one offline and look for starting around 7:42 p.m. in the chat from Dr. Patricia Johnson, who has a particular matter about a case to appeal, and she wants to know who's going to hear her case. If you can just answer her directly in the chat, that would be great. Do you see that? Okay, perfect. Thank you. Let me just, Councilmember Fareed, let me just make sure I don't see. Well, there's one more question from Ms. Churchill. She says this is my question. I live in Dorchester County on the shore. Does this set a precedent that other counties might follow if the law passes? Other counties will just be able to get rid of the overcourse judges. I think you've already answered that, but if you want to make any further statements.
So I just want to be clear, as the law states now, the different counties, they need to basically have a bill. They need to introduce a bill in the legislature in order to basically annex out of this current law. So I don't foresee that happening. I mean, right now, outside of Howard County. And like I said, Montgomery County has been through this and Hartford County has already been through this.
And then this will be the last question. I'm just gonna answer this generically. Someone asked, because this pertains to anything that you have to vote on the ballot. They say, if you leave question 5 blank, does it affect the rest of your ballot? And the answer is no. It will just go unanswered, and it just won't be tabulated as a yes or a no. So you're welcome to skip that. With that, I think we are at the end. Mr. Ford is still communicating with some of the persons on question 4. So we're now at a slight break. We have just completed all 5 of the statewide questions, and we're now moving to our specific Prince George's County questions. I know that there are people, like I just saw someone said they were from Dorchester County. If you have a question on question 1 through 5, if you would direct them to the specific panelists. I believe Beth Huffnagel may have left, but Tracy, her counterpart here in Prince George's County, is still on because she has to answer questions at the Prince George's County level. Feel free to still put them in the chat, but please direct them to the panelists. So either our clerk of the court, Ms. Mahasan El Amin, Ms. Tracy Thompson, even though she hasn't come on, but she's also with the League of Women Voters, and she can get, if she doesn't have the answer, she can make sure Beth Huffnagel will respond to your question. And then Mr. Kevin Ford is still online interacting as well. And I did ask Ms. Thompson to put a link to the League of Women Voters Guide, which includes the questions. The League of Women Voters is a nonpartisan organization, just as our organization is. And so the guide doesn't persuade you one way or another to vote a particular way, but it provides some information. So if you'd like to click on that link to just get some additional information, please do so now. So with that, Councilmember Fareed, we are ready to go to the Prince George's County questions A through E, with our panelist, Ms. Amber Hendricks.
Great, thank you so much. And thank you for being with us, Ms. Hendricks. For questions A through E, I will not read all of them. They are ballot questions for bond issuances for community college facilities, county buildings, library facilities, public works and transportation facilities, and public safety facilities. So I will start this by asking a question about the timing between when we issue these bonds. So, when we're going to vote on them versus when we actually execute on them. Like, when will we start to work on the community college or complete that project? Can you give us a timeline?
Absolutely. And it differs depending on the actual project. So each question is based upon the county council enacting a bill which details the projects that make up the various totals that are in the community college or the county buildings or the library facilities and public works projects. Typically, and when we're having bond bills, we're looking at costs for projects that are going to come probably within the next 2 to 3 fiscal years. So some of them are ongoing projects, and then some of them could be brand new projects. So for example, in the community college, particular bond question is $64.6 million. There are 8 projects that make up that particular total. And one of the projects is, renovation of Marlborough Hall, the student center at the community college, and college improvements. Those are all projects that are ongoing. They're in the design or the construction process, and the county may have already issued bonds in the past, and we're seeking additional authority from the voters to issue bonds in the future. So it just kind of depends on the projects that are a part of that particular question, and citizens can identify the legislation that referred the question to referendum, and those projects are outlined in all of the various bills.
Thank you so much for that. The construction industry now is being significantly impacted by inflation. How are the amounts of these bills being impacted, or has that already been considered in the amounts that are listed?
No, so that is a very good question. And I would say this year, you're probably seeing more projects that where the costs have increased over the past 2 years, because the last time we've been able to send projects to referendum was 2 years ago. And within that 2-year period of COVID, we've experienced inflation, shortages in materials, increase in labor. And so this year, you'll probably see additional projects that, I'll say Shady Glen Fire Station, which opened this year, but it's still on the ballot for asking for additional enabling authority. And that's because the project was finished within the past 2 years, and those costs have increased the total cost of the project. And so now that we're kind of going through fiscal closeout of that project in the current fiscal year, we are coming back to the voters to say we need additional authority to issue bonds for that particular project. Same thing with Hyattsville Library. They had a wonderful opening recently, a couple months ago, and that project you'll see is embedded in the library projects because of those cost increases that we've experienced. And this is now the opportunity to catch up, ask for additional authority so that we can close out those projects. And then you'll have others that we have projects that are sold in perhaps 2024, when now that the 23 budget has kind of caught up in some of those increases. And as we prepare to issue bonds in 2024, we'll need that additional authority as well.
Okay, great. Thank you so much. What is the county's current bond rating, and how will these debt issuances impact that rating?
So the county is currently AAA rated by all 3 rating agencies, and that's Fitch Ratings, Moody's, and Standard & Poor's Global. And so, which is the highest rating that any municipal government agency can have. This particular the bond bills won't have an immediate impact on the county's bond rating. The bond ratings kind of gives the voters their participation in the overall cost in which the county could borrow for a project. But the county's capital budget and operating budget is managed on a day-to-day basis. So when we're going before and we're planning to issue bonds for various capital projects, and we're going before the bond rating agencies, we are taking into account, affordability. What is the current cash flow of the project? What stage is the project in? Will the project be delayed? And so as we are managing the overall budget, that in the actual activities that the agencies are doing and moving these projects forward, that will more determine, how we'll be impacted by our rating versus just the overall approval of getting the enabling done.
Great, thank you so much. And one last question from me before we go to the chat is, how are the projects selected? How determine which ones we should issue bond bills on?
Absolutely. So we complete an entire review of the county's capital budget, and the county's capital improvement plan and budget. It's a 6-year plan, is available on the Office of Management and Budget's website. So we review every project that is in the plan, and we're looking at, have we received, looking at the total project cost, I would say, for each project. And then we're making a determination of all of the other times that the project has been before the voters for approval. Are we exceeding the amount that the voters have approved each year? So a lot of times, most projects may have enough enabling authority for the voters, so we no longer need to seek additional authority. And so you won't see it on the project plan each year, but everything is based on the adopted budget. And then the other reason you could have a project on there is if it's a new project, because we only go before the voters every 2 years. And if the budget that is enacted by the county council includes a new project in which the county will be issuing general obligation bonds, we need to put therefore will require us to get voters' approval before we can issue any debt to finance that project. That would be another reason that a project appears on a list as well.
Thank you so much for that detailed information. I see that there are questions in the chat, so why don't we head over there?
Yes, there are quite a few questions. I'm going back up. So one of the first questions asks, why raise bond money? Are federal infrastructure funds not available for some of these projects in Prince George's County, particularly referencing like the community college?
So no, so the county, I think there's been a lot of discussion about the federal government passing this infrastructure bill, but the county has not received any money from the infrastructure bill. But our project but the needs of the community need to be met. And so in most cases, and our total capital budget is over $5 billion. We are using local resources, to build our schools, to, build projects for the college, our fire station, police needs, to pave our roads. And that always would be the first source of funding available because of the large needs of our community. And then, of course, when we get grants from the state or the federal government, that is also used to help lessen the burden of some of the debt costs that the county will have in the future.
Okay, so someone asked generally, and it kind of covers a couple of questions, to please explain the bond borrowing process. So what's the period for executing the bonds, the entire process once it's approved, how does it go to Wall Street, that so forth and so on? Can give us a quick one.
Absolutely. So I would first say it starts with the budget process, in which the county executive, of course, submits a budget to the county council, and the county council subsequently enacts that budget. Once we, if we're in a period of time in which we need to seek an additional enabling authority, we would submit that legislation to the council in the spring for adoption, in, I would say, early summer before the council goes on recess, and we meet the deadline for a project to receive enabling authority. But that step really only happens every 2 years, because per the charter, it has to, the council is required to send an item to referendum anytime there's a congressional or general election. So if we don't have that, if a project, has all of its enabling authority from the voters, subsequently the administration, the county executive would send down what we call a bond authorization legislation. And that is a little bit more detailed and aligns with the budget that says these are the particular projects in which the county has approved, and we have enabling authority from the voters. And this is what has been budgeted for this particular fiscal year for bonds, for the costs that need to be financed for these projects. Once that legislation is approved by the county council, and we typically would do that, I would say towards this time, before the council recesses in the fall. This particular year, because of the election, the legislative calendar shifted. So you'll see that legislation in 2023 instead of the end of the calendar year. But this is just a particular special case this year. Once we have that authority to actually issue the debt, the county develops what we would call offering documents, where it's all of our financial information about the projects. We would then subsequently meet with the bond rating agencies to kind of get an overview of our fiscal situation, to get our bonds rated. And then we would have a competitive sale process where various institutional investors would bid on the county's debt for the bonds. And then once those bids are accepted, the county kind of closes that transaction. But during that entire time, departments are moving forward with implementing the capital budget and, doing construction, going out for bids, moving forward in which they normally will do. And the county is typically, when we're issuing bonds, reimbursing ourselves for costs that have happened at the beginning of the year, when we typically will have our bond sale late spring, typically closing in May. So hopefully that gives a better timeline.
That's good. We have a couple more questions. I know we're tracking a little bit behind, and we've got to get through some other questions. But someone wanted to know, is it true that bonds are used for lending purposes, and this is why the request for more is being requested?
For lending purposes. So we're using the bond money to finance the construction, the design of projects. So we are borrowing the money.
Right. Two-part question here, try to cover. If maybe you can put something in the chat. Someone wants to see where there is a list of projects which bonds are being requested for. Maybe that's something on the county's website, if you could put that in the chat. And then the obvious question is who determines what locations in the county will be receiving the improvement? So the priority, how are priorities set, and who makes those determinations?
So that is the budget process. The budget plan is laid out there, and based on the needs of the county, there are various plans that impact what gets built first. And it's a 6-year plan. So a lot of the priorities have been laid out and publicly discussed for several years. And, as they come to be built, it's based on the needs of the county as well as the input from citizens.
Perfect. Let's see. Okay, you answered that question. Uh, someone asked, he says, we still don't understand why we continue each election or every 2 years to borrow money to issue bonds. Does this ever end?
No, because the needs of the community never ends. And the reason why, this is required by charter. So before the county can issue any debt to build anything, we have to have a citizen input on it. So the budget is a 6-year budget and a 6-year plan. So there will always be projects that are there that need to be completed. And we need authority from the voters in order to borrow the money to pay for those projects.
Okay, I just responded to one. I think that is it on questions A through E. But again, if you could put in the chat the resources where they can find out about the list of projects that are going out for bonding and infrastructure projects, and where people could participate. The budget hearings are generally early March, late March through April. I believe the county council has until the last week in June to complete the budget process and approve the budget. So be sure when County Executive Angela also Brooks put out a call, if there's a particular project that's a pet peeve of yours and you want it to be done. And again, if it's infrastructure for construction, it has nothing to do with operations, nothing to do with hiring more teachers, operations, those kind of things is not part of this bonding process. But if you want something built, something improved, road improvements, don't sleep on those budget hearings. So thank you so much. Councilmember Fareed, I think we are ready to go to question F with our council chair, Calvin Hawkins.
Great, thank you so much. So this question is related to the compensation of the county council members and the county executive complying with state law. So County Council Chairman Hawkins, can you tell us what the state law actually is?
Thank you for that question, and thank you for the opportunity to speak with you tonight. The question F is a charter amendment recommended by Prince George's County Compensation Review Board. If I may say, the Compensation Review Board by county law and state law is a board that's put together with 3 members selected by the county council and 3 members selected by our county exec, and then the chair is selected by an agreement between the county exec and the county council. And what has occurred with this question F is our Prince George's County Compensation Review Board recommended that this be placed on the ballot, because right now the county's compensation review process is not in line with the state. All this question F does is bring us in line with the state laws and have the compensation of the county council members and county exec comply with the state. We're not getting any additional funding. We're just aligning how we do it with how the state does it. And is a statutory requirement for the compensation between the state law and the charter. And because there's the differences, we had to deal with this. There's really 3 distinct differences that we are dealing with. Namely, under the state law, the deadline for submission of the Compensation Review Board's recommendations varies from ours at the county level. Further, the county legislative body cannot increase any items of the Compensation Review Board's recommendations. So that will stay in place as a result of if this question F passed. And any changes to the compensation or allowance of any of the members of the county legislative body, we have to now enact an ordinance instead of just voting among ourselves to support the Compensation Review Board's recommendation. And lastly, the county exec is subject to the same process the county council has to go through. And as you all may know, or you may not know, that every third year of a 4-year cycle, we have responsibility as a county council and the county executive to convene a compensation review board to look at the compensation of the county council as well as the compensation of the county exec compared to regional executives and legislative bodies, and determine and recommend funding increase, whether it stays together. So that's basically what question F is all about. Just making sure that the county council's compensation review processes and compliance are in line with the state's process.
Okay, thank you for that. Are there any questions in the chat?
Yes, there's quite a few questions, and I think I'll start with one of the last ones first. Can you explain again how the county's compensation process is not in alignment with what state law is? What's the difference? What are we doing?
The state law has a certain period of time it has to be done. And all we're doing with question F is ensuring that our timeline is consistent with the timeline that the state law requires.
Okay. And then everyone wants to know, does it impact how the county council and the county executive are paid? Does it automatically give you guys a raise or a decreased salary? You know, or in other words, no one wants to vote for something that, you know, that's going to put some type of automatic, you know, salary raise in place. So
no, that's not what occurs in this instant. The compensation review study information on salary, benefits, and pensions, providing basis for its recommendations, which, for example, this time around, because of COVID-19 and some of the other fiscal challenges that the county faced, the compensation review board recommended a 12-month freeze in any type of increase in the county exec's salary as well as the county council member's salary. So it's not automatic. They're looking at the fiscal situation of the county. They're looking at whether it's necessary to increase our salaries, our pension. And I also want to say, if you get a chance, you can go on the Prince George's County Council website and you can review a copy of the pension review, the compensation review board's recommendations. You can see what thoughts they had about our county charter, and there's a list of them. You can go back some years and get an idea that these are not individuals that are there just saying, hey, let's find a way to increase their salary. Let's find a way to expand their pension. They're looking at it from a regional state perspective, and they're looking at our fiscal forecast before they do it. You all had Amber Hendricks on prior to me, and they bring in our director of finance, our individuals from the Office of Management and Budget, our auditor. So they're talking to different fiscal experts and individuals responsible for the county's fiscal forecast to ensure that they have much information as possible prior to making any recommendations on how to move forward. And I strongly recommend that you take a moment, if not tonight, sometime tomorrow or over the next few days, to take an opportunity to review that report, and it'll give you a better appreciation that you're not voting on question F to increase the county exec and the county council members' salaries. Again, this is just, it has nothing to do with money as much as it has to do, question F has to do with getting us in compliance with how the state, like how the legislatures look at the governor's compensation and all of that. So we'll be in compliance with the state, how they do it the same period of time.
Okay, thank you. And if you could put that site, I also asked your counterpart at large council member Mel Franklin to add that site and put it in the chat. That would be great. And for those of you still on, Ms. Hendricks not only listed the county bills for the specific bond issues, but she also included her PowerPoint presentation for tonight. We didn't have an opportunity to incorporate that into this presentation tonight just because of the length of time, but feel free to click on the download button to get more details about bond bill questions A through E.
Madam, Sister Davis Brown, do you want me to email to you and you can put it in the chat, my notes on the different questions that we use? They are our official notes on the various questions, or you all okay? I can send it to you via email.
So we do have the legislative history, and I'm
Okay.
gonna ask our moderator if she could download that document at some point as well. We have the legislative history on all of the county bills, and so we'll include that in the chat as well, if we could do that. Let's see. What time is it? It's 8:14. I see a question from our dear, and I have to acknowledge her, former regional director, Emma Barron. I believe we answered this question, but the reason I asked what time it was 8:14. She asked, why is it necessary to have the county compensation process be aligned with state law? And the chairman mentioned that it had to do with timing. So I'm not sure if you missed that portion. But we will put in the chat the legislative history as to why this question was necessary. And hopefully that will give you some more information. But in the interest of time, we're going to go ahead, Councilmember Fareed, if we can move to question G, please stay on, Chair Hawkins. It's your.
Thank you. Question G is regarding gender neutral language and changing that in several sections throughout the charter. So changing it in places where it says he or she to them. That's what is meant by the gender neutral language. So can you just speak to this a bit, please?
Yes, question G is about gender neutral language, and over several years, different charter review commissions had recommended, but this time around, under the leadership of this council, including with at-large council member Franklin, we took the Charter Review Commission's recommendation. And the purpose of question G is just to change the text of the charter from gender specific to gender neutral. And hopefully you ladies of Distinguished Alpha Sorority Incorporated could appreciate that. There are 97 references to he in the charter. Question G changes he and her to them, their, and they, and changes were also made to council member, chairman, and councilmanic district. In other words, we're making our charter gender neutral in out of respect for the role women play and the role individuals who have pursued different directions, but still a part of our county citizenry.
I do not see any questions on that particular one. I think it's pretty straightforward.
It is.
So I'm going to go to the next question, but I'm looking at another question from the previous one. I may have misunderstood it.
While you looking for Sister Barron, while
Yeah,
we
that's what I
also
was looking-
have to be in compliance because of the 23 counties in the city of Baltimore, I think 2 counties and the city of Baltimore, 2 Prince George's County being one of the 2, we realized we were not in compliance. So those 2 counties, along with the city of Baltimore, we had to become in compliance. But in order to do it, we had to do it through this question on the ballot. Because we're changing our charter.
Okay. So okay. I think her question has been answered. If not, just put another question in the chat. I am working on getting a download for you. If we can proceed to question H, please. Councilmember Franklin should be on. Thank you, Chair Hawkins.
Thank you, and you all have a good night.
Thank you.
Thank you. So this next question is to include county law for the encouragement and support of local and minority businesses, consistent with requirements of federal, state, and county law. So the question to you, Councilmember Franklin, is why is this a charter amendment versus a resolution, as an example?
Good evening, everyone. I want to thank you so much for having me this evening. This is so with our county charter, as you all know, the charter is essentially the county's constitution. And so some of the time things are put in the charter to state principles or values that we then use as the basis for, when we make laws and when we do regulations, we refer back to a principle or value that's stated in the charter. And this is one of those that we are stating a principle that we want to encourage and support the greater utilization, greater investment with our local and minority businesses, provided we conform to the requirements of federal and state and county law. So this is actually not one of the more specific charter questions on your ballot. This is more of a statement of values related to local and minority businesses.
Thank you. My internet is a little bit unstable, so if you can go into the chat question for this.
So I don't see a chat question on this one yet. I did want to also piggyback, and Council Chair Hawkins did a really good job of talking about the compensation charter question. The biggest thing it does is also put into the county charter that the county council cannot increase the compensation recommendation of the compensation review board. We can decrease it, but we can't increase it. So we can't. So if the compensation review board, which is supposed to be an independent body, recommends something for the compensation of the next council and county executive, the council right now in the charter language could go above that recommendation. But that's what our staff told us is not consistent with state law. You're not supposed to be able to go above the recommendation of the independent compensation review board. You can only go below it and reduce it. And so that's really probably one of the biggest things that charter question that you just talked about does. Yes, and to that question, the charter is the county's constitution. County can never go beyond federal or state law unless federal or state law expressly authorizes us to do that. So sometimes federal and state law can be a floor and they tell us, well, we can go above what they do, but they have to explicitly authorize that. in the instance of compensation, the state is expressly stated what the counties can do, and the charter has to conform to that. We can't, because of the idea of the county is essentially, the state is superior to the county, and the federal government is superior to the state in the areas it has jurisdiction. We cannot go above or go beyond what the state tells us we can do.
Okay, thank you. So I'm back. I got my questions back. Is the current county law inconsistent with federal, state, and county law regarding minority businesses?
It is not. No, we're not consistent. In fact, we take great pains to comply with federal law. For example, with our minority business program, we just completed what they call is a disparity study, which is a study of comparing how the county is spending when it comes to contractors who are minority businesses in compared with what we should be spending. And so we have disparities, particularly in areas of construction contracting, particularly for Black-owned businesses in our region. So we're using that disparity study to now update our minority business program. Just as we speak, we just passed a new policy yesterday to substantially increase our minority business enterprise program, and for the first time create sub-goals around African-American business enterprises, and in some situations, other racial subgroups. But we noticed the biggest disparities amongst African-American owned businesses in how the county spends, they call it procurement, how the county contracts for services, construction, professional services, goods and supplies. The county spends $500 million annually on spending to procure services for our residents. So to build the next school, to build the next police station, to pave the next road, to operate the bus service. All of those things are done through the county doing what they call procurement or doing contracting with private sector businesses. And so what we've seen is that we need to strengthen our laws around requiring more of that spending to be done with minority-owned businesses, particularly those here in the county.
Thank
so I think
you.
I just answered the disparity question. So we have big disparities in a number of industries for Black-owned businesses, construction being one, IT being another, architecture and engineering contracts being another. So there are a number of areas where we have disparities, professional services, for example.
So thank you. With that being said, and noting all the disparities, should the language be required as opposed to encourage? The language in this amendment is saying it encourages.
So the charter doesn't. So the charter, just like the Constitution, is a little more general in its language. The charter is like that too. And so we will spell that out more in the county's code, our statutes, where we get a lot more specific on the particular requirements. There is hesitation to get too specific in the charter because of the nature of the document. But the charter oftentimes provides the impetus for then enacting county laws, and oftentimes provides the authority for enacting county laws that spell this stuff out much more specifically.
Great, thank you. Are there any questions now?
Yes, but I think the councilman has addressed some of these. Let me just go back. The first one was, what is the definition of local or minority for question H? And then I guess you can combine that with, does this primarily apply to businesses with owners residing in the county?
So there are a couple of different aspects to how we require projects to utilize, we call diverse suppliers. So that's suppliers that are minority, and it may mean suppliers that are local. I'm not to get too complicated, but the Supreme Court has really limited how much race conscious we can be when it comes to the laws we put in place to help our Black and other minority-owned businesses. We have to really jump through a lot of hoops to do race conscious goals, we call them, and generally we have to do them as goals and not hard quotas, as the term of art is. Quotas are hard requirements. Goals are, we'll say, you have to use best efforts to hit this number. And when it comes to race conscious things in the law, the Supreme Court has limited our ability to do anything more than goals when it comes to race conscious ways of helping our Black and other brown and minority-owned businesses. That said, we've come up with other ways to get at the same thing. So Prince George's County's business community is very diverse, and particularly small business community. So we have requirements on contracts that we're just increasing that say that you have to spend a certain percentage with small businesses based in Prince George's County. Now, for those, we can have hard requirements because they're not race conscious. They're based on race neutral standards, but they let us get at the similar goals because our local business community is so dominated by minority business enterprises. So that's one way we try to get at the same thing without running afoul of federal law, namely the Supreme Court. And so responding to some of the others. Yeah, so minority actually is a broad term. Minority, and this has been part of the problem. Minority means any racial or ethnic group, but it also means women of any race. Okay, so that's white females as well. The problem there has been that we've seen that some white companies use that to game the system. The business will really be owned by and run by a husband, but his wife is being put forth as the owner of the business for them to get minority status. We've seen that happen fairly often. One of the ways we're responding to that is now we're going to create sub-goals that are specific to African-American owned business, Latino owned business. So these goals are going to actually push these contractors that are majority-owned contractors to hit numbers specifically with Black-owned businesses, not just minority, which is a term that is far too broad in a lot of ways. Now the question is as to what the percentage that we're going to go to for minority business is going to vary based on the industry, and that's based on the disparity study. So for example, if you're in the construction industry, the new requirement, which used to be 20%, is now going to be 43%. The requirement for African-American business in the construction space is going to be 23%. And right now there is no requirement for or goal for African-American business enterprise. So that's going to be brand new actually. And other industries is a different goal. It's a different standard. So for example, professional services, the standard might be in the 30s for MBE and 15% for African-American business enterprise. All of these things were based on the disparity study and what it found as what was our capacity availability in the marketplace in those industries as minority businesses, but also as those sub-racial categories of business as well.
Great. I think you have hit on most of the questions in the chat, so I appreciate that. We can now move Councilmember Fareed to question I, which at-large council member will stay on for this one as well.
Thank you. So question I is actually for county competitive bidding. It's to provide that public notice for bids or proposals shall be advertised on a publicly available website designated by the county purchasing agent and in any other manner determined by the county code. Such purchases and contracts shall be made from or awarded to the responsive and responsible bid that is most favorable to the county with respect to best value, including technical requirements, diversity of suppliers, and costs as defined in the code, to provide for bonding and generally regarding competitive bidding. So we can pop that language in the chat for those who don't have a ballot handy. And so, Councilmember Franklin, the question for you is that, this appears to be typical contract language. What is the rationale for adding this amendment to the charter?
This really is about, so when you put something in the charter, you really want it to be permanent. You really want there to be a permanence to it. It's harder to change something in the charter than it is a regular law or a regulation. So, any couple of months you could change the law in the county council. But the charter, when you put something in the charter, it's going to stay there a while. So one of the reasons for putting this language there was to cement, if you will, some important standards for our local minority business community, particularly making sure that the diversity of suppliers is a factor when we're awarding these contracts. Oftentimes that's not a consideration, and we want to make sure that the charter states that it is. We also want to put more firmly into the charter the notion that best value, it should be the standard, not simply the lowest bid. Oftentimes, our local minority businesses are disadvantaged because they can almost always be underbid by a larger majority-owned contractor who does not have the interest of providing the best value to our taxpayers for the projects that are being funded by your tax dollars. So we wanted to cement that into the charter, those were the main things we were trying. The other thing I will mention is we wanted to update how notice happens. The charter was still saying things like you had to post, notice needs to be in 2 newspapers of record. And so, that's language from the 1970s and 1980s. And so we wanted to modernize how notice has to firmly happen for these contracting opportunities. So that was one of the reasons for putting that in the charter. We already have that in our county law, but we wanted that to be submitted in the charter as well, and to make that those 2 things consistent.
Okay, great.
So the county council does not award contracts because that'd be a conflict of interest. What happens is that we approve a number of contracts that the county executive seeks to enter into, or we may approve a contract that our council administration is seeking to enter into. But we as council members don't actually do the awarding of the contract, but we do have say in approval of large contracts, multi-year contracts, for example. But the reason we need to change the laws is there are a lot of contracts that don't have to come to us for approval because either they're not multi-year contracts or they're not large enough in their nature. So we want to make sure we put laws in place, even for the contracts that we don't have approval over, to make sure that enough of those dollars are being spent with minority businesses here in Prince George's County.
Great. Thank you. Are there questions in the chat related to this? We know that the language on
yeah, we just put the question in the chat. It's been placed in the chat twice. So that was I think I went in, we did this presentation on Canva, and I'm not very good with Canva, and I think I went in and messed up a few slides, so I apologize for that. So again, question I is to provide that the public notice for bids or proposals shall be advertised on a publicly available website designated by the county's purchasing agent and any other manner determined by the county code. Such purchases and contracts shall be made from or awarded to the responsive and responsible bid that is most favorable to the county with respect to best value, including technical requirements, diversity of suppliers, and costs as defined in the code, and to provide for bonding and generally regarding competitive bidding. So as Councilmember Franklin mentioned, one of the reasons for updating is, it used to be the newspaper. I think one of the newspapers no longer even in publishing. Isn't that correct?
Exactly.
So,
right. And quite honestly, the newspapers of record were I believe the Post, Prince George's Post, and maybe the Sentinel. I don't know, the papers that you have a hard time finding.
Found it exactly. So that's one reason. That's one issue. This question does cover multiple things. So one has to do with notice, and then the other has to do with best value for our tax dollars, obviously, and making sure that whoever we select in the procurement process, that they provide the best value, which not only includes the lowest cost, but also diversity and other, as it says, technical requirements. So let me just make sure I didn't miss. So I think we answered that. I'm looking for the first part of Mr. Scott. Okay, does being notified publicly allow the public to have impact on the decision and the selection process?
So the selection of contracts is actually, it has to be very non-political. So you can't have, so for example, if there is a procurement put out there, bid put out there by the Office of Central Services. So the department that the county has that does procures and gets contracting services from the private sector is called the Office of Central Services. They put in place these items of criteria. People bid, private entities, private contractors bid on the contracts based on that criteria and based on those requirements. And then they have to make a decision based on that criteria. It can't be it can't be something that's done, that a decision is made without adhering to whatever criteria they put out publicly for that bid. So that's to safeguard against corruption. It's to safeguard against political sort of decision making that can lead to litigation. Because if a contractor bids for a project and they had the best bid based on the criteria, you can't give it to anybody else. You got to give it to them. And if you give it to somebody else, it will be litigation, and they'll simply the courts will simply block the contract, and it will be a bad look for the county. So that's why you have this whole quote unquote procurement process for contracting, so that there isn't that sort of politics being played with who wins the contract. All that said, we do want to put requirements in place that make it require that a good chunk of that spending stay with businesses here in Prince George's County, particularly small and minority businesses. And so the way we do that is we put that into the criteria at the front end. And so everybody who bids is on notice that they have to meet those requirements.
Good. Okay. And then this is going to be I think Ms. Page's question has been answered by what you just said. Hopefully, she heard that. And just point of clarification, in terms of the notice, is it not going to be a requirement for media, or is it going to be still both? But also,
it's not going to be required to be in print media, no.
Okay. So, Karen, so no print media. She also asked, how would this not be consistent with Maryland law and Title VI requirements?
It would be consistent with both. Title VI, I'm not sure what that's related to, but Maryland law, it definitely complies with Maryland law.
Okay. Okay, yes, we answered those questions, and I think we've got only about 15 minutes, but thank you, Mr. Franklin.
Sure.
If you have more questions, or if there's some other resource information we did put in the chat, we downloaded, we'll put it, if we can put that again, just in case people missed requested the download of the legislative history for all of these bills, including particularly the county questions, but also the statewide question. If we can put that in as a resource for those online. Let's see.
And one thing I want to also mention, you might ask, why are we spending all this time talking about minority businesses here in the county? One of the ways we want to grow our tax base so that we can reduce the burden on residential property tax owners is by growing our small business community and growing that part of our tax base to help fund the services that we all care about: schools, roads, transit, public safety, all of those things. The bigger your small business community is, the bigger your business community is, the less that we as a jurisdiction are going to be reliant on residential property taxes, which are, as we all acknowledge, are way too high. So if you ask, why are we going about this activity? Why are we focused so much on small businesses here in the county, minority businesses here in the county? Part of it, yes, generational wealth, but also part of it is grow our ability to fund the services we care about by growing our business base, not by taxing our residential properties.
Okay. Miss Karen Sanu did, and I'm going to have you just answer directly to her offline. She said public participation requires print media, and that's what Title VI is about. So I'll let you answer that offline. But Councilmember Fareed, we are ready for the last question, question J, which I'm hoping is the right one on the slide.
Yes.
Yes, and we will now have Miss Tracy Thompson, who's been waiting patiently, but she did supply us with the League of Women Voters voter in the chat. So hopefully you have that. And if we can spotlight Miss Thompson, thank you.
Do I need to read the question?
Thank you.
No.
No, I was waiting for you to spotlight. So the question is, to provide that an at-large council member shall have been a qualified voter of Prince George's County for at least 1 year immediately preceding their general election. Council members representing one of the 9 council districts shall have been a qualified voter of their respective council district for at least 1 year immediately preceding their general election. In an election year following an approved decennial redistricting plan changing the boundaries of any council district, the 1 year residency requirement immediately preceding the general election shall not apply if a person is deemed qualified voter but no longer resides in their former council district because of a boundary change in the approved decennial redistricting plan. So this is similar in some respects to question 2 on the Maryland ballot, but it has some differences that, in my opinion, are make this something that's a bit more palatable. So Ms. Thompson, if you could speak to a little bit of the history around this, particularly in Prince George's County, that would be great.
Absolutely. And like you just said, this is really related to the Maryland question 2 on residency requirements that Beth Huffnagel already talked about. So this is a very similar question, but just for Prince George's County. The Prince George's County government did an analysis of this question. And pardon me, I'm going to read from their report. In light of the issues surrounding the most recent council redistricting process, it may be useful to clarify the terms by which a person shall be elected to office within a respective district. So after that, the census was delayed and the numbers were late, boundary changes were late, and then the Prince George's County Council recommended some boundary changes as well. And it caused a lot of confusion about who was going to represent which district, who was qualified to even be on the ballot for that district. And so that's why this was created. One of the big changes is it changes the countdown, the 1 year time requirement. It used to be tied to the primary elections, and now it's proposed to be tied to the general election. And then a specific change for redistricting purposes is they've now added this new language that explains what's going to happen if there is a redistricting plan that changes the boundaries, because that language was not present at all, and it was very confusing with this last census go around.
Okay, thank you for that. Do you think that the difference in the 1 year versus the 6 months is important, and also the fact that it will not apply? Sorry, let me go back. It shall not apply if a person is deemed a qualified voter but no longer resides in their former council district.
That's a really tough question. I don't think that the 6 month period is really that huge, because the person still has to be a resident of Prince George's County. And so this is just if a census redistricting plan changed the boundaries, or the county council changed the boundaries, then that person could theoretically be in a bind and they have to move somewhere else. But there's still going to be a Prince George's County resident who has lived in Prince George's County and was eligible to vote in Prince George's County. So I personally don't see that 6 month time frame as a huge issue, in my opinion.
Okay. Okay. Are there any questions?
Yes, there's a question in the chat that asks, why didn't they use the same language, i.e. maintain a primary place of abode, as opposed to this language?
That is an excellent question that I do not have the answer to. This came up in a county council, It then went on to the Prince George's government, and both were approved. There was a public hearing that was made available on this question. And so I don't know the specifics of the language.
It's tied to where you're registered to vote.
Okay. Did we hear that from Council Member Franklin? It's tied to where
Yes.
you are registered to vote.
Right.
I'd like to say one last thing. Oh, there is another question. Sorry.
The question is will there have to be a special election if a council member is redistricted out?
That is a question that I do not know the answer to. I will let our council member Mel Franklin tackle that one.
Can we spotlight
Okay.
Ms. Council at-large Council Member Franklin again? Thank you.
Sure. No, the answer is no. Sitting member is not affected by redistricting, because the redistricting applies to the next term, or the next council member and their term. So it wouldn't affect a sitting member.
Okay.
In my opinion, what this does is really protect somebody who's running for office, and then the redistricting comes around, the boundary is changed, and then that person suddenly is not eligible to represent that new area. And so this is protecting them.
That's a great point, as I know personally. I do not see any further questions. We have only 8 minutes left, and there are some closing remarks that we have. Was there anything else, Ms. Thompson, that you wanted to add?
No, but thank you for this opportunity.
Okay, thank you. Well, Councilmember Reed, thank you for a job well done in moderating our panel on this evening. We got through, I hope, most of the questions from the audience, and if not, that they got questions answered through the chat. We did put the legislative history back in the chat a second time. And if we can advance the screen, I want to thank the president of our chapter, Ms. Kelly Jackson, for opening us up. I want to especially thank the connection people, the people who are working behind the scenes to advance the slide, put the presentation together. Definitely kudos to our technology committee. This cannot be done without them, especially in a virtual format. So we certainly appreciate that. We would like for everyone to take our survey. We can go back to the survey. You should get a request for that through your Zoom confirmation, but it is on the screen. So we appreciate if you could take the survey. And we are seeing some good feedback in the comments. So thank you for that feedback. But if you could certainly also provide that same feedback in our survey, that would be most appreciative as we get best practices and what we can do to help improve this forum. This has, we typically do this forum, as our president mentioned. We've had forums like these, not only virtually in 2020, but also in person. And so continue to look for us to be of service to you, to provide information and provide some educational updates about what's on your ballot. I see our president is back on and spotlighted. If she wants to provide any closing remarks, we love to hear from her.
Sure. Thank you so much, Tamara. I'll just echo what I posted in the chat. Thank you so much to our panelists for providing such wonderful insights into all of these ballot questions. And thank you so much to all of our attendees. And I just want to congratulate you on making the decision and the commitment to make yourself a more informed and educated voter so that you will not have that deer in headlights look when the ballot question page comes up on your ballot. Thank you so much.
With that, we bid everyone a good night with 5 minutes